Hi, my name is Nick Weiss. I am the owner and supervising attorney at MP Weiss Law. I want to talk with you about things that you can do, your best practices as a client to make for effective representation, to help your attorney, to help your legal team to get the best outcome for you possible. An attorney-client relationship is a two-way street. We have a lot of duties and a lot of obligations to you. We have to represent your best interest to the best of our ability. But you have duties too, as clients, and things that you can do to make our job easier to get through the best outcome. And it all starts with the initial call, the initial intake. If you're calling me, if you're calling the firm, you're probably talking to me, or you might be talking to one of our under intake personnel. When we do that, the goal of the intake is to, as quickly as possible, set up the scope of your issue, the scope of your problem, get the appropriate facts, and see if that is something that we can help you with. So this is not the opportunity to give every fact and every type of issue that you have. We're trying to see what you're calling about and seeing if we can help. And most of the time that's limited to a half hour to an hour. So we're not going to be able to do a very deep dive. So come to your intake prepared, have your documents, email them to me ahead of time. That is very helpful, especially if it's a document heavy intake, so that we can establish clear communication and I can give you an honest assessment of your case and whether we can assist with it. After we get done with the intake process, if we think that we can help you, we may send to you an engagement letter. And that is a contract between you and the firm. And we may also send you a deposit request. Both these things are very, very important. That contract sets out all the things that we're going to be doing for you, but also a lot of the expectations that we have for you as a client. That includes things like clear and regular communication, using our existing processes to get information to us and your legal team, which includes using our secure client portal for almost all written communication and especially transferring documents back and forth. You agree to that as a condition of signing up. You're going to use that secure portal to protect you, to protect us, and to make sure that everyone on your legal team knows everything that's going on, rather than going to different specific people. You're also going to have a requirement in that deposit, and that is a number that maybe I came up, maybe someone else came up with, that you have to maintain as a condition of representation. And you have to maintain that throughout the representation. We will bill against that deposit as we do work, and then you have to replenish it. If you don't do that, we do reserve the right to stop work or to withdraw. So that is another one of your obligations. After you have hired us, your next obligation is to get us all the documents, get us all the facts. These can include all of the relevant documents that we might have already talked about in our intake. If you've got a real estate matter, certainly a purchase agreement or other contractor agreements that are on there. If you've got a family law matter, that's going to be a lot of the things that we're going to need in the case. That's going to be last 3 years of tax returns. That's going to be bank statements. That's going to be, if it's a custody issue, information regarding your kid's school and medical, right? And making sure that we get those documents and that information timely and quickly will help us to begin representing you. And also making sure that we are fully disclosing everything that we can to your attorney and to your legal team. Everything that you say to us, from the moment you call in and talk to me at the intake to the end of the case and beyond, is protected by something called attorney-client privilege. That means that anything that we discuss while you are seeking legal advice, we can't tell anyone. We can't tell the court, we can't tell opposing counsel, we can't tell anybody, because that is your right as a client. And that means that you get to tell us all the bad things, and I want you to tell us the bad things. I want you to tell us everything that the other side might say, not because it's true, but so that we can prepare and we can be in the best position to advise you as to whether we need to take a deal, whether we need to settle, whether we need to go to trial. But if we don't know those bad things at the beginning of the case, that will increase your cost, that will increase your time, and depending on how long into the process we find out about that bad thing, that can lead to a bad result for you. Make sure you're communicating regularly with your legal team. That includes both the attorney that's assigned to you and the paralegal that is assigned to you as well. You might be dealing with that paralegal quite a bit. That's not because we don't think that you're important. We are fortunate here to have a very strong paralegal corps with many years of experience that can do things like answer questions for you, give you status updates, request documents, help you fill out discovery. Help them to do that. They know what they're doing. And the reason we're having them do those things and not us isn't because I don't want to talk to you. It's because their billable rate is lower. We are trying to be cost effective for you. That also goes to respect, and this is a big one. In any litigation, any legal matter, emotions can get hot, especially if you're here for a family law matter, if you're here for a contested probate matter, emotions can go high. If we get into hot conversations between you and your attorney, we understand that. But one of the things that we take very seriously here is how clients treat our support staff. That's our paralegals, that's our office administrator, that's our admin. You can let loose a little bit on your attorneys because we get it, even though we ask you to be professional. But any kind of abuse, anything on the line to our support staff, we will take very seriously and may lead to termination as you as a client. So, even though you're frustrated, even though you want maybe to speak to the attorney, not to the paralegal, save it. Save it for your talks for us. And that's basically it. So long as there is full and fair communication, so long as you are disclosing things, so long as we are doing regular check-ins, and we are giving you a full and fair analysis of your likelihood of success in your legal matter, which we can only do if you have given us that full disclosure, then you at MP Weiss Law can have a good attorney relationship, and we can get a solid outcome for you in your legal matter. Thanks.